Most of the time, if someone has a house or if a married couple has a house, then we're going to be dealing with a probate due to once they pass, that house is in their individual name, then it's going to have to go to probate, even though the will might designate who they want it to go to, because if it's in their individual name, it's still going to have to go through probate.
Hey everybody, we are here today discussing the exciting topic of estate planning. Actually, you'll be surprised. It is very interesting and it's super important to have that done. But Mark Kollasch is joining me here. He's an attorney with the Access Law Group that specializes in estate planning. Mark, tell me a little bit about estate planning. Is it hard for people to actually just start the journey of estate planning?
Absolutely. And thank you so much for getting things set with this. I think that first step you just mentioned, really approaching estate planning, is usually the hardest step to get rolling, because as soon as you start thinking about estate planning, that means you're thinking about death, and you have to think about all of the different things that come with that. And it can be very difficult. It's not uncommon for people to put it off just because they don't want to think about it or have those conversations. So getting over that hump of, I don't want to think about it, to I'm going to address this head on, is usually the hardest part of the process, because after that, we're solving problems. And when you've already gotten that issue out of the way, solving the rest of the problems actually can be a lot of times a really good feeling of accomplishment to get things set the way you need to.
I felt that same way. Starting off, it's like, oh, I have to think about, my death, their passing. I have to think about my mom or my kids. I mean, nobody wants to do that. But, I think in a way, it's actually kind of the greatest gift that you can give, the survivors, to have your estate planned and organized. If you just look at how, someone's passing is difficult in itself. And, it is the top stressor of the top 10 stressors in somebody's life. And of course, it is so life-changing for most people that really wanting to deal with red tape is just so tough, and having that planned ahead of time, I think, just is a huge relief, and it's a great gift. What are the most common things that keeps people really from starting their estate planning?
Obviously, one of the biggest is lack of knowledge. That's something that we run into a lot, where most people think, if I don't have millions and millions of dollars, I don't need to get anything set up. And unfortunately, that's just not true. And especially when we're looking at times changing and laws changing, there can be a situation where you think something is already set, and even so, it might not be as set as you'd like once the law changes. But currently here in Colorado, our courts deal with any estate through the probate process that has real property, so any house, land, mineral interests, or if your estate adds up to total assets of $80,000 or more. So most people, when you're thinking about estate planning, in some way might fit one of those categories. And so I think the lack of knowledge and just sort of not wanting to address it is one of the biggest things. But I think some of the other big barriers that come in the way of people addressing their estate plan are the time and money that it can take to get things set. Because time, this is obviously part of that not wanting to think about death and address it and hit it head on. But
I'm way too young to think about it. Right?
Absolutely. Or sometimes people even think, I don't want to have to deal with it. Somebody will deal with it after I pass. But just like you said, that's putting more stress on them when they're already dealing with the passing of a loved one. And so the time aspect of it, there is some parts of this process when we do an estate plan that can take some time. We like to make sure that we're addressing everything that needs to be addressed, because we don't want there to be any questionable things in there. We don't want to have a hypothetical that comes up that we haven't addressed. But honestly, our process can be as quick as anyone wants it to be. So the time aspect of it, yeah, there is some time as with any plan that you're setting, but the time also can be a lot less than people are expecting. And same thing with money. You know, a lot of people think, I don't want to have to pay. I could maybe go download a document online for a couple bucks and do it that way. But unfortunately, when we're dealing with an estate plan that hasn't been done correctly or that hasn't been invested in, it ends up costing more money after you pass than investing in it now. And so dealing with a probate or dealing with assets that haven't been designated to go into the right place, that's going to end up costing more than coming in and getting something set would cost initially.
What I would like to know of the people that are watching this, if they have started an estate plan, and if not, what might be holding them back from doing it. Please leave a comment below. And if you have any questions, of course, drop those down there as well. And we will answer, either via email or in the comment section itself. Of course, to the extent that we can. So what I hear a lot, whether it's my own relatives or it's actually my clients, when I ask them, hey, have you done an estate plan? I often hear, well, we have a will. That's fine. What does the professional say?
Unfortunately, in most situations, a will can be very helpful, but it's not going to be as helpful as people think. Most of the time, if someone has a house or if a married couple has a house, then we're going to be dealing with a probate due to once they pass, that house is in their individual name, then it's going to have to go to probate, even though the will might designate who they want it to go to, because if it's in their individual name, it's still going to have to go through probate. And there's some different situations, not to get too far into the weeds, but there are different situations where you can address that. However, simply naming that you want a house to go to someone in a will
is not enough
to do it. Right, exactly.
So just to kind of define probate, for me, that was never really clear. Can you elaborate about probate? What does it mean? How long does it take? And what does it cost?
Absolutely. So probate is one of those things that the law requires because, there are different theories why it's required. I get that question a lot of just who decided that this needed to happen. But really, I think that the state wants to make sure that significant assets are passing the way that they're supposed to. If we don't have a will, then we're actually looking at Colorado law on where things are going to go. So really, it's just a process where a court oversees where things are going, makes sure that the law is being followed, and make sure that an entire estate is dealt with before we're just closing the book on that chapter. So
that's difficult.
It can be very difficult, and the other unfortunate part of it is the time and the cost, again, that it can take. Here in Colorado, we're looking at a minimum of 6 months. That's what the law says a probate is required to be open for. So best case scenario, if a probate's open, it won't be closed for 6 months. But in reality, most of the time there are some speed bumps along the way, maybe dealing with creditor bills or other issues that come along. The real bad scenarios are where we're looking at people fighting. If a family member wants to inherit something and they decide to contest a will, or they decide that they're going to contest what the executor, or what we now call personal representative, if they contest what they're doing, that can add time on to the process. And so those situations can take closer to a year and a half. So that's a process that we always want to avoid. And I mentioned the cost. Even on the simple probates, if we're dealing with assets having to be distributed, paying creditors, it can cost between $10,000 and $15,000 when it's all said and done. And so as the time goes on, cost is going to go up as well.
Yeah, I was just going to say, and of course, the longer the court proceedings last, I'm sure that's not free, and costs stack up, and whatever goes to the court doesn't go to the heirs. And yeah, who wants to give courts money? So
Exactly. And that's unfortunately what the probate process does, is it takes money out of the heirs or the descendants' hands and puts it into court fees, legal costs, that sort of thing.
So we're talking a lot about wills, but apparently they're not great. What is an option to the will?
When we approach an estate plan, we're really wanting to look at what's going to be best for the specific situation. And so, looking at some people's situations, if you don't own a house, if you don't own land, if you have your assets down below that $80,000, in some situations, going with a will and maybe doing some beneficiary agreements or designations might work. But most of the time, if we're dealing with significant assets or even something that just is going to get pulled into probate, we're going to be looking more at a trust. And the reason we like trusts is because by definition, something that's in a trust will avoid probate, because if the trust owns it, trust will continue on after someone passes away. One of the big things that we're always wanting to address is guardianship for minor children. And while that's done in a will, that's something that you can really address even better in a trust.
It makes so much sense to have a trust over a will. I think there's more control. I have always been wary about a trust because I thought that if I have a trust, I don't have control over my assets anymore.
Right. And that's one of the past understandings of a trust that's starting to be developed into making trust more common, because for a lot of years, trusts weren't very common. And when they were made, it was what we call an irrevocable trust. But for most people, we don't have to look at an irrevocable trust. We look at a revocable living trust, which means you're still in charge of everything. You can change things, you can move things in and out of the trust. And then once you pass, it essentially functions similar to a will, where whoever is appointed as successor trustee is required to do the things that you put in there for distributing your assets.
And I didn't understand that, before I got into real estate, that you actually have to deed your assets into the trust so that they're actually protected. Can you elaborate on that?
Yeah, absolutely. We here at Access Law Group, anytime we're creating a trust, we include a deed transfer for the real property that you have. So most people, when they're getting a trust, they're going to want to move their house into the trust. And the reason is, again, because that house in their individual names would be getting pulled directly into the probate process. So we go ahead and move it from their individual name into the name of the trust. That makes sure that when they pass, it goes and is distributed directly as the trust would say, completely avoids the probate process. And yes, that is very important, because a lot of times if that's not done, even having a trust and just saying that your house is in the trust isn't going to be valid unless it's on the title itself. And that's true for any assets. We actually, for things like bank accounts, other things like investment accounts, a lot of times we'll just say, go ahead and put the trust as the beneficiary on those accounts. So that way, when you pass, everything goes into the trust and then again is distributed exactly according to its terms.
Okay, so I picture a trust basically as an umbrella. And as long as whatever you own that is important to you or is above $80,000 is in that or under that umbrella, it gets protected, and whatever is outside is not.
Exactly. And there are a lot of different techniques for, again, different situations where, maybe we'll want to put something into the name of the trust right off the bat, like with the house. Maybe in other situations, we just want to use beneficiary designations to go ahead and have it flow into the trust after you pass. And there's a lot of different techniques. And again, we really want to make sure that the best thing is done for the individual situation. But yeah, I think looking at it kind of as an umbrella or just something that we can cover the assets with, that's really going to be a priority.
If someone wants to start to get their estate in order, what is the very first, most simple thing, the first step to do?
So really, I think that the first step I recommend is talking to an attorney. Here at Access Law Group, our initial consultations for estate planning are totally free of charge. and typically are around 45 minutes so that we can go over what's necessary, how to approach your estate plan, and how to make sure that everything is lining up in the way it needs to. And so we provide those free of charge just because, again, that bump of getting over the barrier of thinking about it, thinking about our own mortality and trying to get things organized for the future can be the most difficult thing. We want to make it as easy as possible.
And personally, I feel it would be a real good idea to just sit down, think of all your assets, basically make an inventory of your assets, whether it's house, accounts, anything that you are connected with, benefits, as well, maybe even social media. That is a whole different thing, but that is coming up more and more often, that people need to actually have all kinds of social media things set up so that whoever, is responsible for that after you pass has access to it. That is a totally different story, but I feel it needs to be mentioned. But yes, I think it's a great idea to start with an inventory of all your assets that are worth protecting or that you want to see protected. And, and then a list of people that you would like to be involved. And I think even before maybe anybody gives you a call, maybe talk to the people that you would like to be involved after you pass to make sure that they're actually willing to be the designated executor or trustee, right? That's the right name?
Yep.
So that they actually are not surprised or just kind of blindsided that all of a sudden they're responsible for that.
Right. I always encourage people to have full communication about their estate plan. Obviously, some situations, there may be some things that are sensitive. There may be things that you want people to not have all the information about, but as often as possible, I recommend having these discussions with anyone who's involved. And we do, throughout our process, sort of walk through how to get the right people in the right place. We also sometimes, if people want, we'll have a family meeting where we'll go over everything with the family. And I think as much as you can do that throughout the process, before the process, after the process, it's going to make sure your wishes are executed in the way that you want them to be.
All right. Awesome. Well, Mark, thank you so much for this. Let's call it a primer into estate planning. We will have a few other videos going a little bit more into detail about the different kind of generations. So we have the young ones that definitely don't think about estate planning, because I for sure didn't. And then, of course, another generation, I would assume it's maybe more into the Gen X generation, because they're pretty much sandwiched between the young ones and the parents. And then last but not least, the boomers generation. Gosh, that sounds so derogatory, but the boomers generation. So we're going to have a few other conversations. Make sure you check those out as well, and check those out as well. And we're looking forward to seeing you there.